So, good afternoon, everybody. We're very happy to have you with us today in our second speaker series event of the Tech Policy Hub. Today, we're very happy to discuss how can empiricism improve privacy enforcement? How can privacy research and privacy regulation inform one another? And as always, we're bringing in a scholar in the field and a practitioner to give us their unique perspectives on the topic. So before we give the floor to our great speakers today, I want to quickly introduce the UMD's Tech Policy Hub, talk about our goals, the things we do, and how you can subscribe and stay up to date with all that is happening. So the goal of the hub that we created is to try and bring together scholars and practitioners from the wider DC area, right, from the DMV area, who are working on tech policy issues, both from a research point of view and from a practical point of view, so industry and policymaking. And the goal is for the two communities to have kind of an institutionalized space to inform one another and hopefully eventually improve tech policy cycles in Washington, D.C. We created what is known as issue networks, so network of experts around four pressing tech policy issues: cybersecurity, consumer privacy, information integrity, and trustworthy machine learning. And across each and every group, we have the projects that the hub facilitates and works on, publications already published in that space, and scholars affiliated with us. Let me quickly share with you how our website looks like. So these are the different topics that we are dealing with. We are also having a monthly newsletter to celebrate the achievements of scholars affiliated with us, to discuss upcoming events and tech policy news, and maybe some career news for our students interested in tech policy careers. We're having a speaker series like today. We already have the recording of the first event that took place 2 weeks ago about AI governance. So the recording is here for those of you who registered and couldn't make it or want to revisit the concepts and things we talked about, and we'll upload the recording of this session as well to the website. So to stay up to date with all the things that are happening, I encourage everyone to hit the subscribe button that you can see here. That's at the bottom of our homepage, and stay again up to date with all that we do. And lastly, before we move on to our amazing speakers, I want you to save the date for our annual Tech Policy Hub event. It's going to take place on June 6th. It's an in-person event in College Park. We already have four amazing confirmed speakers. So Miss Lee Turdrich, she's an expert in AI governance. Dr. Cody Bontain from the Info College, he is expert in information integrity. Dr. Charlie Harry from the Public Policy School and the Info College, a cybersecurity expert, and Paul Ohm. He's an expert in privacy law from Georgetown University. And the goal of this event is to bring together scholars and practitioners to the same room for hopefully meaningful exchange and collaboration. There are no registration fee, so it's free of charge. It's open to everyone, and we'll share registration links and full agenda soon. So again, just make sure you subscribe. We're going to have panel on artificial intelligence, misinformation, cybersecurity, and privacy. And each panel will have both scholars and practitioners at the same panel. Each panel will start with a research presentation by a scholar, and then a practitioner has to respond. So we are creating those exchanges between scholars and practitioners on purpose to inform and improve research and hopefully improve practice, as our speakers will discuss soon. Okay, so now I want to introduce our lovely speakers for today. And we are very happy to host Dr. Aileen Nielsen and Dr. Mehdi Arfaoui. They will discuss how empiricism can improve privacy enforcement, right? And they will give us the intersection of privacy research and privacy regulation across the US and the EU. Dr. Mehdi Arfaoui is a sociologist at the CNIL, which is the French Data Protection Authority. Arguably, that's just my opinion, one of the best privacy regulators in the world. He's part of the, Aileen agrees, he's part of the CNIL's Digital Innovation Lab, also known as LINC, where his research focuses on the intersection of technology, regulation, and digital practices. A key area of his current work examines the intersections between science and regulation, as he will talk about today, exploring this dynamic relationship between academic research and regulatory bodies, particularly concerning personal data protection. He is a research associate of the EHESS, which if I had a good French, I will try to say the full name, but I don't, so I'll leave it to Mehdi. But this is where he carried his PhD thesis, and his broader research interests include the modernization of public action, platform work, and the political sociology of data. So thank you, Mehdi. We're very happy you're with us. I also want to introduce Dr. Aileen Nielsen. She's a visiting assistant professor at Harvard Law School, where she teaches privacy law and torts. Her research focuses on the interplay of law and technology, drawing on empirical methods and private law topics. She holds degrees in anthropology, physics, and law. She has written 2 trade books on machine learning and has also worked in industry as a data scientist. Aileen is also a member of the New York Bar. Okay, so speakers, the floor is yours. You both get to discuss your take on the topic of today. We'll start with Mehdi, and then we'll move to Aileen. Then we'll have some guiding questions, and as we move forward, we're collecting questions from the audience. So feel free to put things in the Q&A. Mehdi, the floor is yours. Thank you.
Thank you so much, Aido. Can you all hear me properly? Yeah. So thank you very much also for the very kind introduction. Thank you, Aileen, for the opportunity to exchange ideas today. So indeed, my name is Mehdi Arfaoui. I'm a sociologist at the CNIL, the French Data Protection Authority, and I'm here today to discuss our research program, which I so far entitled The Lab and the Regulator. The idea with this research program is to investigate the crucial interface between science and regulation. But before I dive into the content of this presentation and this research program, I thought it'd be interesting and important to quickly present the CNIL and the Lab for Digital Innovation, the LINC. So first of all, the CNIL is as I already said, the French Data Protection Authority. So it enforces GDPR, as well as e-privacy directives, so specifically concerning the issue of cookies, and the French Data Protection Act, which has actually inspired the GDPR. To do so, it works as an administratively independent body with an 18-member board. This board includes the chairwoman of the CNIL, of course, which is nominated by the president and then elected by the parliament. 4 members of the parliament, 2 members of the Environmental and Social Council of France, 6 representatives of the highest courts of France, and 5 qualified personalities, like, for example, computer scientists and social scientists. It is also in size a substantial organization with around 300 members, including mainly a mix of legal experts, of about 48% of legal experts and about 20% of computer scientists. It is also important to mention the fact that the CNIL does not take any order from the government. and that the budget is voted by the parliament directly and does not depend on any ministry, for example. Going from there, the CNIL gives itself several key roles that actually go beyond the only enforcement issue. First, the CNIL has for a mission to inform. The CNIL responds to requests from both individuals and professionals. So anyone basically facing difficulties in exercising their rights can contact the CNIL to have information. Second, it provides advices, of course. The philosophy of the CNIL is to help organizations, both private and public, to comply with GDPR by offering a range of tools before actually enforcing and sanctioning and controlling and so on. Third, of course, the CNIL also enforces law. So the CNIL conducts control to verify compliance with the GDPR. We have the power to require organizations to correct their data processing and also impose sanctions like fines, for example. And at last, the CNIL aims to anticipate issues related to data protection, and I guess that's why we're all here today as well. We aim at detecting and analyzing new technologies and new types of users that could significantly impact privacy. A key part of this anticipation mission of the CNIL is led by the LINC, so our Lab for Digital Innovation. The LINC stands for Laboratoire d'Innovation Numérique de la CNIL, which itself has for mission to explore the future of digital society, develop both internal and public tools in favor of data protection, and as well as exchanging with a diversity of social actors, including, of course, academics, which is also the reason for my presence today. To do so, the LINC consists in a team of 7 interdisciplinary members, bringing together expertise in social science, computer science, and design. So as I mentioned, in addition to our research production and experimentation and so on, the LINC also holds internal seminars called Research at LINC. These seminars cover a range of topics and are available to watch online. So you'll be actually able to find Aido's presentation on privacy enforcement on our website, video.cnil.fr. In addition to, the CNIL, in addition to this, the CNIL also hosts an annual academic conference, the Privacy Research Day. And actually, the upcoming Privacy Research Day will be held on July 1st. So I take the opportunity of this seminar to encourage you and to tell you that the submissions in all disciplines are welcome and open till the 31st of March. So let's get to the content of the research program I wanted to discuss today by first reminding ourselves why it is important for the CNIL to study this interaction between science and regulation. I would say that there are at least 3 main reasons for this. First, there is, of course, a strategic imperative to do so. Indeed, leveraging scientific production can lead to greater efficiency in regulation. So understanding how this interaction between science and regulation works can lead to better informed and more effective data protection policies. Second, there is for us an empirical opportunity, of course, because being embedded within the CNIL provides us with a unique insider's perspective, allowing for real-time observation of the evolving regulatory landscape, and also the ability to observe the already ongoing interaction between science and regulation. And at last, there is a more fundamental insight, I think, that is interesting. Because our research produces knowledge, of course, on social dynamics that can be used by other researchers from that do not necessarily work inside regulatory or authority, public authorities. And so showing how scientific knowledge is used, debated, integrated, or not into legal frameworks, we think can interest many So to explore this science regulation divide or interaction, we examine in this research program so far 2 case studies, but we hope to enlarge the quantity of research studies we go through. So if you ever have ideas, I'd be happy to discuss this during the discussion. I think these case studies illustrate how scientific knowledge is appropriated or not within the regulatory process. They highlight the need for regulators to address both, we'll see, institutional on one part and on the other part, technical barriers to effectively use scientific knowledge. So before we dive in, I wanted also to offer a disclaimer. This is, of course, ongoing research, so feedback is welcome. And also due to time constraint, I'll be skipping over the methodological aspects, but please ask if you have any question about that. Our first case study looks at dark patterns and cookie banner regulation. So as you may know, there is strong scientific consensus on the existence and manipulative nature of dark patterns online and with design and interfaces. Those evidence are supported by typologies and statistical evidence produced by academia. The academic community, from design, computer science to law, is actually very active in this area and pushing for regulation to go further. So my central question here is, why is their work so little integrated into cookie banner regulation? To answer this question, we use science and technology studies as well as legal consciousness studies framework to analyze the institutional barriers that impede the translation of this scientific consensus into effective regulation. No, that was too fast. Yes, okay. So here are our preliminary results on this first case study, and I hope they will interest you. Our research shows that regulators are themselves operating within power struggle. So a significant concern for regulator is the fear that their decisions will be overturned on appeal by courts. In the meantime, what we show is that law and science relate differently to the notion of fact. Whereas in science, academics seek for like material truth, legal people and in law in general prioritize evidences based on their ability to fit into the legal procedure. So there is a binding legal procedure that needs to be obeyed by the evidence, and it happens that a solid scientific evidence be dismissed if it doesn't adhere to those procedures. What does that mean concretely? Concretely, that means that scientific arguments often require a process of what I will call proceduralization to be usable in legal context. So it's sort of a translation into a legal procedure of the scientific evidence. One other important issue is also that the regulator follows a case-by-case approach, focusing on how specific applications of the rules work, which results in a selective view of reality. For example, statistical evidence, global statistical evidence is often deemed to be too general in a legal context because it does not concern the very specific case that is studied in the complaints. And at last, we have identified an issue of strategic avoidance, that's how we call it, where legal actors might avoid scientific evidence to make their decisions because methodological limitation of scientific studies, which is normal in a scientific work and from a scientific perspective, can in a legal context be disqualifying the legal decision. So lawyers may prefer to not use scientific evidence. I hope that was not too fast, and I propose to go to the second case study, and of course, do not hesitate later to just ask me as many questions as you want on those both case studies. I wanted to have it short. So our second case study examines the field of explainable AI, or the so-called XAI, and the challenges of embracing the opaque dimension of deep learning systems explainability. So what we can say is that the XAI field lacks a strong scientific consensus, in opposition to dark patterns. There we do not have a scientific consensus. And most methods produced by the field are mostly heterogeneous, not necessarily so robust or reliable. And so we miss concrete techniques to have for deep learning system calculations. Yet, regulators are called upon to address the rights for explanation and establish, of course, a regulatory framework. That's true. That was true already with the GDPR, but that's even more true with the AI Acts that both actually contain mentions of a right to explanation from AI systems. Of course, this situation necessitates that regulators engage with the internal workings of the academic field of XAI to understand the limitation and potential of techniques produced by XAI. And that's also the reason why we chose this case study. It's that it's directly interesting for the CNIL and regulators in general. As for the results, our study shows that XAI field produces a wide range of heterogeneous techniques, as I mentioned, reflecting an attempt to address multiple demand and criticism regarding AI. So basically, what academics in XAI want to do is answer desiderata and stakeholders asking for proofs and having criticism against AI. We argue that this subordinates position of XAI with the broader field of AI, meaning that XAI is subordinate to AI because it helps AI finding a protection, prevents XAI from effectively tackling the fundamental problems of explainability and achieving scientific consensus. We show that XAI is actually heavily influenced by the need to provide solutions that make AI perceived as transparent, responsible, marketable, and so on. And this influence can sometimes prioritize unrobust short-term solutions over fundamental research and rigorous scientific inquiry. Therefore, I hope you understand that from the point of view of the CNIL, understanding the field's structure, the actors' incentives, and the dependencies of academia is crucial to assess the potential and limitation of XAI techniques in the regulation. To conclude, I wanted to give you a few levers for improvement that emerge from both case studies. So as you noticed, both case studies highlight the need for stronger links between science and regulation and scientific and regulatory domains. And I want here to conclude with those levers for improvements. What I think is that first, we need a clearer communication of regulators' needs and processes. We need regulators to show how they can articulate scientific evidence to their work, their concrete work. And that will probably help scientific and academia better operationalize their work to make it easier for them to align with regulation. Second, I think we should consider on one side embedding always more scientific expertise within regulatory bodies. The LINC is a good example of how regulatory bodies can incorporate scientific expertise. But on the other side, we also need to establish dedicated intermediaries to facilitate what I called before the proceduralization of scientific evidence for legal use. We need some people that are able to make that translation from science, scientific evidence, to legal evidence. We also think that regulators require a deeper understanding of scientific context. That's also why we wanted to lead those case studies, because understanding and acknowledging internal power dynamics within academia is a major issue. And finally, we think that cross-domain education is essential. Providing, on one side, lawyers with a training on how concretely the scientific and academia in general works is really important. And on the other side, offering scientists an education on the intricacies of legal frameworks is really important for them to align their work on regulation. I also wanted to point out that we also need to push for, and that's on our side, from the regulators side, to open more and more the data that is held by the regulators, so that academics can use it for scientific purposes. When it's possible, make sure that regulators make this data available. Thank you for your attention. Let me also repeat that we intend to enlarge the list of case studies that we have to better grasp this science regulation interaction. So if you have any idea or want to partner, you have my email on the screen. Sorry, I hope I wasn't too fast or too long, and sorry for you. Thank you for your attention.
Thank you, Mehdi. That was wonderful. Aileen, before I move to you, just two quick reflections on Mehdi's talk, and all of you, please feel free to put your questions in the Q&A box. Just to give some context about the CNIL, Mehdi mentions how independent it is as a regulatory agency, number one, and how much it devotes efforts in trying to anticipate data protection and privacy problems. This is very, very unique to the CNIL, right? We have seen cases where those agencies, the data protection agencies, are not so independent. We have seen cases where they, usually have lack of resources and don't have the manpower and capacities to invest anything in kind of try to foresee what is coming from, from the industry, from emerging technologies. So I just wanted to highlight how unique this is for a privacy regulator to be both independent and proactive from a technological point of view about what's upcoming. And the second reflection I wanted to make is you introduced maybe two different cases, and I think one interesting dimension in which they're different is the strong versus weak scientific consensus on what to do, right? So dark patterns and the way they're used in cookie banners is a well-studied. We have the know-how, but there are some obstacles in implementing that in the regulatory process versus explainable AI, where we even don't have the know-how, but there is urgency to regulate better for accountability demands. So these are two kind of very different places to be at from a research point of view, and how that translates to the regulatory process is fascinating. Do you want to quickly respond, or should we move to Aileen and take it later?
That was perfect as a transition. Thank you.
Okay, awesome. So thank you so much, Aileen. The floor is yours.
Okay, let me just go ahead and likewise share some slides. Can I have some indication that you can see my slides? Okay, great. So I'm really delighted to be here. Ido, I want to thank you and everyone at the Tech Policy Hub for creating this event. And Mehdi, thank you for the wonderful research that's so interesting that inspired this event. So really a pleasure to be here exchanging ideas. I wanted to just sort of both talk about some of my research, so some shameless self-promotion, just because what does one like talking about if not one's own research? That's why one goes into academia. But also to maybe back out a little bit from the discussion we're having so far, and in particular, think about what does it mean to improve privacy enforcement. So as we're going to be thinking about how can we have empiricism be at the service of privacy regulators or of government in the presumably the sense of privacy promoting reforms or enforcement, that nonetheless, this question does not have just one answer, far from it. And I think that can easily be reflected in the sorts of empirical privacy research one can do and the conclusions one might draw from it. So obviously I can't completely answer this question, but I propose just to highlight a few possible responses one might have. So a non-exhaustive list of the kinds of viewpoints one could have about what it means to improve privacy enforcement include the following. A consumerist viewpoint. That is a viewpoint where we're thinking about consumer choice, about data subjects or individual humans who are surveilled, thinking about sort of what they want and what they're willing to trade for it. We can think of privacy enforcement improvement from what I call a protectionist viewpoint, which some might also call a paternalistic viewpoint. I avoid that word because in the US, that tends to be a conclusory word for bad, but it need not be, right? We can say, no, protectionist is about taking a normative stance and enforcing what is necessary to respond to that stance, right? The idea that certain things we're going to call good outcomes and we're going to try to promote them or maybe even guarantee them. There is a structural viewpoint where we look at this question from the viewpoint of thinking perhaps there aren't intrinsic preferences or intrinsic good outcomes, but it's all a matter of how different elements of society interrelate, and it's all about sort of being enmeshed in our sort of socio-technical systems, and that might inform sort of how we research things and how we think about what enforcement can or cannot do. And finally, a formalist viewpoint where we essentially say, well, we don't think about what privacy is for. We look at the privacy laws on the books and we simply say, are these laws enforced? Are they respected? Because we think lawfulness is kind of a per se good. So let's look at how this could manifest more specifically, right? So the consumerist viewpoint, the idea is give consumers what they want. Now, of course, that assumes that consumers know what they want, that we almost kind of relate to being in the world most as consumers. We can expand this a little bit to give consumers or citizens what they want. Again, thinking of us each as kind of atomistic beings who are able to kind of pursue our own well-being. And this kind of viewpoint, if one adopts this, will then look to making sure that the mechanisms that are meant to be in place for ensuring autonomy, for ensuring the ability of independent entities to pursue their choices, to make sure those conditions are in place. So, for example, one might look to market health. Are privacy markets, are consumer markets that relate to privacy functioning as they should? Is the information that's needed available? If not, let's make that information available. And by the way, the market, you're probably thinking of goods and services like Spotify or Facebook, but it could also be in the democratic sense, right? So it's sort of the democratic market working, right? Where we think of sort of spending our votes rather than our dollars or our data. Likewise, in this viewpoint, one would be thinking also about market growth, right? If we're operating on the idea that sort of more exchange is better, then we want more of that. And again, that would be sort of the stance we might adopt, and that can inform what one might study or the conclusions one might draw from studies. So I'll give you an example. I have an ongoing project right now that I think of as privacy agents, the idea that one can look to software or some kind of entity to secure one's preferred privacy outcomes. This is not an idea I invented, but I find it amazing we don't talk more about privacy agents. So one thing I've been doing lately is sort of a historical study of the literature to see this term is not very widely used. It is used occasionally. So for example, here I show you a German computer science master's thesis from 1999. So this is Meyer's work. And even back then, he was already envisioning something that we still don't have, but that I think we all still probably want. The idea that when we pursue some kind of online transaction, that necessarily comes with some degree of data collection / commercial surveillance. And the idea was, wouldn't it be great if we had some kind of software agent that could sort of see what the terms available vis-a-vis privacy were from the seller, that could negotiate with the seller, that could kind of enforce the terms that we, the consumer / user / citizen want, and to have that all happen through software rather than through burning through our cognitive cycles. Because of course, we're humans, we don't have limitless cognitive cycles. We would rather spend them on more important things. So recently, so this is ongoing work, we have this new phenomenon in the United States. It's a product of state law, but in some states now, you can have a privacy agent. It's called global privacy controls. What I've done with a co-author recently is study whether anyone is using these privacy agents and whether people are able to use these privacy agents if we sort of give them a very little education about it. And what we show See, attempting to move forward, pardon. We show two things. Firstly, we show that people right now are not really using privacy agents. The existing privacy agent is called Global Privacy Controls, GPC, because this is a tech-savvy audience. Some of you may have heard of this, but it's really very little known and very little adopted. On the other hand, we also find that if we tell people about GPC and suggest that they download this privacy agent, that almost 80% of them do. So this sort of coincidence, as it were, as in coincidental happening at the same time, facts, the fact that there's very little adoption, but that when you tell consumers about this technology, there's very high adoption, that tends to suggest some kind of market failure or informational failure that privacy enforcement or privacy messaging could correct. So if one takes a consumerist viewpoint, this might be one way that one would do empirical research about privacy. And one set of inferences one could make would be something like, oh, our markets are not working so well because we have this solution, people seem to like it, but they're not adopting it. But let's think about a structural viewpoint again. So we could imagine if one takes this stance, one version of this stance is something like consumers or citizens get the environment their privacy gives them. So in other words, we're not looking at consumers and citizens as being very powerful to effect change in their environment. Rather, we're understanding all of us individually as surveillance subjects, as data subjects, as sort of acted on by our environment far more than we can act on our environment. Likewise, we can go even further and say it's not just that we get the privacy our environment gives us, but also the privacy our environment teaches us to want. So the idea here is we humans are not born with, say, intrinsic preferences or understanding. It's something we get from our environment. So, for example, where might one be concerned, or where would empirical privacy research lead us here? I show you two surveys from the Pew Research Center. So this is a very sort of widely used, long-standing survey center. They're nonpartisan organization. They run surveys of Americans, large-scale surveys on many topics, trying to understand how do Americans feel, what do they think about, what do they talk about, and so on. And every so often, Pew asks about privacy. So I give you two relatively recent surveys. In 2019, there was a survey looking at how essentially pervasive Americans thought surveillance was, how able they thought they were to sort of avoid surveillance, both by private firms and by government if they wish to do so. And then I have on the right another survey, this one sort of looking at whether Americans feel concerned about this and also whether they feel they have an understanding. And from this, I might again look at, well, the reality Americans live in, that from a structural viewpoint, they may have very little sort of individual autonomy or agency to change or to push back against, is one, they believe they are widely subject to surveillance, and two, they feel that they don't even have very much understanding about that. So that's a different kind of empirical insight into privacy, and sort of the conclusions one draws, again, might be inflected by the viewpoint one is adopting. The protectionist viewpoint, actually, just by the way, to go back, structural viewpoint, this is also very much, I think, in the vein of Mehdi's talk, looking at XAI, right? So thinking about, and again, it's not just about the data subjects, thinking about the regulators and the empirical researchers themselves as also kind of being enmeshed in this structure, and very much having to sort of account for those structural realities when they're thinking about what to research or what they can or cannot do with the products of that research. The protectionist viewpoint, as I call it, or the paternalist one, is something like privacy is good for democracy / society / public health, and more strongly, perhaps, therefore, some minimum should be enforced. This is usually not the viewpoint you find most widely reflected in US law. Mehdi, please give me pushback if you disagree, but my impression as an outsider looking at the European Union's history of privacy regulation and data protection regulation is that this might be a fair, simplistic description of European privacy law, sort of the idea that this is sort of a social good. This is a thing that is good for us, and therefore the state will step in to promote it, just as they would ordinary public health or the health of the democracy or the health of the markets. So you can also take different views within the protectionist viewpoint. You can take something like the democratic viewpoint. This is good for democracy. We don't want surveillance that stifles expression, that stifles political activism. And so that leads to conclusions like, oh, reducing data flows, reducing data storage are desirable outcomes. One can also take something that looks more like a dignitarian viewpoint, and one finds this as well in my observation of European privacy law and policy, and that can be something more to do with cultural values. We culturally don't think that humans are appropriately subject to the surveillance, not even for the instrumental reasons, but it goes to the dignity of the human. It goes to freedom. It goes to joy. It goes to family life. These sorts of things. So an example of research that might go to this question is to sort of elicit, are there deeply normative impulses individuals have vis-a-vis certain data collection practices? So here I present a study I did looking at how ordinary people judge the sale of either data or paper. And the key takeaway is simply that there's a huge gap, that when you look at people sort of refusing, saying this is not something that should have a price on it, basically everyone is fine with pricing paper. Sure, sell the paper, price the paper. On the other hand, a very large proportion of people, right, hence there's this huge gap, don't like the idea of pricing data or selling data, not just their own data, but just sort of the data of a third person. They view this as perhaps crass, perhaps morally problematic, perhaps just so intrinsically dangerous to that individual that it just seems not worth it. That individual could have identity theft and so on and so forth. A very extreme version of this would also be something like effectively you're commodifying people by commodifying their data, right? So one inference here, if one were taking this protectionist viewpoint, is something like, to the extent we see normative judgments about the marketplace, maybe we should have rules and enforce rules that kind of bring about a respect for these cultural norms in the marketplace. One could infer that. Okay, and finally, I close just with an observation of the formalist viewpoint, right? So this would be the idea of laws should be enforced or respected simply because they are law, right? Perhaps they have the democratic legitimacy, some body of democratically elected legislators articulated this as the law. It has the force of democratic legitimacy, whatever the policy judgments or technical judgments that are baked in, it is good because it is law. In other words, lawfulness is per se good. So in this sense, improving privacy enforcement would simply look like more legal compliance, more enforcement. We could look to things like efficacy, high rates of legal compliance. We could look at justice, high rates of legal punishment. And if this is the viewpoint one is interested in, right, not in thinking about what should be the law or sort of what goals does law serve, but simply is law respected, is law understood? Here I present some work which actually I was privileged to present at the CNIL a few years back. This is a project I have looking at open source compliance with law, and in particular we studied activity in open source that went to bringing open source code into compliance with GDPR. And what I want to draw your attention to here is we get these insights into temporal points of high legal salience. GDPR came into effect in mid-2018. When we look at open source activity, we see there was a huge bump in activity in response to that initial date of the law coming into force. On the other hand, when we look to other sort of socially important enforcement actions or sort of very busy days or weeks for data protection in Europe as a whole, or if we look to enforcement actions that garnered a lot of media attention, we find that none of that correlated with increased open source activity. Now, one can draw a few conclusions, but from a formalist viewpoint, if one simply thinks about how do we get the most attention on the law, whatever the law is, we learn something here about the key statutory dates where legal enforcers can really hope to be most influential. So what have we learned here? Hopefully a few things. The two things I wanted to call your attention to are first, that there are many lenses through which to contemplate how empiricism can or should inform privacy enforcement, even what questions we are asking empirically, right? The questions we find interesting and the inferences we draw from them will very much depend on these lenses. And by the way, they're not mutually exclusive. You might have a few of these lenses at the same time. Secondly, these interpretive lenses typically invoke some kind of explicit or implicit norm, right? So we can't avoid norm making of various kinds when it comes to privacy regulation. And in fact, probably more than other areas, say environmental regulation or securities regulation, where there are sort of some clear external sort of just facts about what makes things safer or less so. Often with privacy, almost everything can be understood as a trade-off between privacy and some other social good or individual good. And so this normative lens is that much more important.
Wow, Aileen, thank you so much. I've been studying privacy enforcement for a while, and I thought I got the hang of it, but then you come and you introduce additional, lenses and dimensions I haven't thought about, and you have the tendency to do so. So thank you for that, and that's why I always love listening to you. I think a burning question, out of your presentation is a question to Mehdi, wearing the hat of a practitioner here. What improving enforcement actually means to you, from those four, very different but interesting, maybe collectively, lenses of how we can improve enforcement.
Yeah. Well, that's a tough question. But reacting to Eileen's question, to Eileen's presentation, well, first of all, was so passionating. I think I would actually use those lenses to better define and yeah, build our own frameworks. Is the fact that, and you said it at the end of your presentation, those lenses mostly articulate depending on the situation. So those viewpoints do not have necessarily some sort of hegemony in an institution or in a country. It just depends on the situation, maybe the power struggles that you won't find. And so one lens might be more useful in a situation because you want to define that point of view, and another lens might be. So I would say what would be so interesting is to see as a researcher how the power struggle and the situation, concrete situation, define and kind of shape the lenses that will be chosen to proceed. Yes, that does not answer your question at all, but I would just wanted to react to the presentation. What was it again?
Sorry to interrupt. That struck me as being the very pragmatic regulatory dodge right there, which I mean in a complimentary way.
Thank you. Thank you both. That was great. So we have some good questions from the audience. Before we get to them, I just want to give maybe even a bit of more context to our audience, and then we can dive into those questions. So I think it might be interesting to kick us off with, what is privacy in the US versus the EU context, right? Because I guess many of us know that, it means slightly different things. Classic EU divides that to data protection and privacy, while in the US we treat them, as one. So can you give us just kind of a brief overview on those different privacy perceptions across the Atlantic? We can start with you, Mehdi.
Should I start? Yeah. Aileen had it. I mean, definitely in the EU, privacy is perceived as a fundamental right. So, especially the GDPR shows it. It views privacy as a human right that intends to be applied comprehensively to any field of society. Whereas I think in the US, it's more like appears to come from like consumer protection and is built from a sectoral point of view, depends on like sectoral businesses and so on. And actually, Aileen, you talked about consumers in the framework, and that shows how that comes from this viewpoint. Also, what's important to mention is that in the EU, privacy is a personal right. And that goes together with fundamental rights. It's the individual that has the right to defend his own privacy. So GDPR, when you look at it, someone cannot defend your data instead of you. You are the only person that can defend your personal data. Except if you actually go to someone and sign papers saying that you want this person to defend your rights. But in most cases, you're the only person that can defend your own rights. Yeah, and maybe one last thing is that I would say maybe privacy can be taken in a wider sense, because it takes the whole process through which data is being manipulated. So GDPR looks at how data is collected, used, stored, shared, and that goes again together with the idea that it intends to be applied to all fields of society and integrate all actors that at one moment may have a look or may use the data.
Okay. Okay. Aileen, do you want to give us kind of the US context of things?
Sure. So I'll agree. I think Mehdi's characterization of the U.S. legal treatment is pretty fair. Of course, we also have some restrictions on what the government can and cannot do with data, which might in fact be quite important in the Trump administration's early moves vis-a-vis their data use. So it's not that we don't understand privacy as more than a consumer protection right, but consumer protection has been kind of the most common and sort of broadest paradigm we have for privacy. I think also to build on what Mehdi is saying, to sort of show some hubris as an American commenting on European data protection. But nonetheless, one thing that has always both fascinated and inspired me as an outsider is, for example, data protection in some ways can be much broader than privacy in ways that, for example, I perceive from the outside to go towards especially these structural concerns or the protectionist concerns, right? Like something like privacy in the American sense is good for democracy. And the way you can see that translated in Europe is, for example, even information that's publicly available can have legal protections, which is unheard of in the US, even now that we have kind of a new wave of ongoing privacy reform that is both inspired by Europe and meant to improve privacy protections here. We don't dream as anything that broad, that somehow the protection relates to the fact that it's about the individual. For us, it's always kind of about the secrecy and the information control. So it's not just kind of a matter of emphasis, it's even some fundamental conceptions of what privacy is for and how broad the scope is that the state will recognize are really different in these two places.
Yeah, thank you. Thank you, Aileen. Okay, so I have, of course, more questions, but we also have good questions from the audience. So I think I'll ask one more question to give some context on the privacy regulatory space compared to other spaces, and then we'll move to the audience, and then we can follow up with more questions from me. So question, I guess, to both of you. Is privacy really unique in this challenge between, in the challenging practice of researchers informing regulators, right? So what are some of the challenges, obstacles for researchers to inform privacy regulation? And how is it in any shape or form different from other regulatory regimes, right? And from other relations we might see between academics and regulators, like in financial markets regulation or environmental protection. Like, is privacy really a special case of that challenge, or just, following existing trends of trying to inform regulators to do a better job?
Should I start?
You can, yeah.
Okay. Yeah, I think that's a very interesting question, and I suggest that I answer it from the angle of the CNIL, of course. So with regards to the specificity of privacy, what we can say is that the CNIL was one of the pioneers in France and perhaps even in Europe as a regulator to reflect on this relationship with science and to recognize the value and the need to integrate advanced research in the regulatory process. but I think it's not because we thought about it before and so on. I think it's because the need for science is particularly true for our objects and our subjects. As for most people, the circulation of data and the capture of personal data are very discrete, sometimes even more invisible processes, right? So on one side, we need computer science to understand like what technical devices concretely do, for example. We need social science to understand how users understand these situations and how organizations appropriate law in the same time. And finally, because it's the third discipline that we have in the lab, we need design research, because all of this is often materializes in interfaces, right? So I think the specificity of our objects and subjects made it necessary for the CNIL to look at it from a scientific perspective. But I would say that since I would say 10 years now, it's been generalizing to at least most French regulators who now tend to nourish this relationship with academia. And I think that actually the Article 40 of the DSA that allows digital service coordinators to access platform data for specific assessment, for example, will definitely push in this direction. So I would say there is specificity, and at the same time, all this is converging, because it's kind of obvious how useful integrating science is.
Yeah, thank you, Mehdi. It's interesting how, in the DSA, they actually, devote a specific article for this exact need. I think it's wonderful, from a research point of view. Aileen, any thoughts you have on this?
Sure. Some complementary observations to what Mehdi has already put forward. So one is I just think privacy is different in part just because at least here in the US, we've just decided it will be different, right? Our regulatory schemes are just far less active, far less resourced. There's far less mandatory reporting, for example, in other industries. Not only is there greater fact-finding capacity, both pragmatically by staffing, but also formally through mechanisms of law, there's just less mandatory reporting in the case of privacy, right? So formally and informally, there's just sort of less that can be done without external assists from researchers. So I think that's the reality here in the US. For example, the FTC undertakes very little of its own research or investigations. They try to crowdsource things from researchers. They try to keep an open line, but there's not much capacity. I think another thing that's different, right, apart from that lawmakers have simply decided it will be different here, is sort of the expected economic or democratic governance in this area sort of has different stakeholders and different bedfellows. So I think to some extent, we in the US are all somewhat vested in environmental protection or financial stability. Of course, nothing hits everybody the same, but I can easily identify how those at the top and at the bottom have something to lose with regard to clean air or financial instability. I think that's less the case with privacy, and the powerful versus the weak are differentially affected and in very qualitatively different ways vis-a-vis privacy, right? So of course, there's the famous example, say, of Jeff Bezos being subject to a blackmail attempt vis-a-vis some pictures he had sent to his girlfriend at the time. And of course, he was able, because of his very socially and economically powerful position, to push back on that in a way that, for example, most women who are usually the victims of such attacks are not. So thanks to, say, the work of Danielle Citron, we are aware, for example, of the very different gender effects we have for ordinary people vis-a-vis privacy. Thanks to Kashmir Hill, we have sort of groundbreaking work on Clearview AI that we didn't even know about before. And we also know that has differentially impacted people. So I think that's another sort of key difference vis-a-vis other regulated domains, is simply the stakeholder alignments look very different and tend to align the powerful and the powerless far less often.
Yeah, I couldn't agree more. We tend not to really, invest efforts in opening those, black boxes of technology that mediates so many social processes, but somehow are shielded from meaningful regulation. Yes, Mehdi.
yeah, I wanted to add something to this. I think it's really interesting to take it from like the very material aspect of things, and of course, depending on the stability and the resources available in institutions, you will not have the ability to build this this relationship to science that much. I wanted to add something because I mentioned earlier the availability of data to scientists. And I think one specificity of the CNIL and privacy in general is that our decisions are public. Some other regulators, they deal with secrecy and cannot make the decision public. And so that does not become material for investigations, scientific investigations. I think very early in time, the fact that our decisions are public made it easy for scientists to just look at what happens and try to have a historical analysis and so on. And you showed Aileen a graph showing how compliance to GDPR was going. So yeah, this type of research is possible if data is available, and that's also why I wanted to insist in my presentation on the fact that that's clearly one lever.
Yeah. Yeah, it might also, encourage a culture of compliance when companies, the fact that they got fined or punished or sanctions is getting, public. But we can definitely discuss that further. So let me pause for a second on my list of questions because I want us now to move to the audience. So we have very good questions in the queue. And we will start with Dr. Sebastian Bental, who has two questions for you. I think one in response to Mehdi's presentation and one in response to Aileen's presentation. So, Dr. Bental, the floor is yours. Hopefully you can speak now.
All right.
Yes.
I think I hit the right buttons. Hi. Thank you both for your presentations. I had a question primarily directed at each of you, one each. For Mehdi, I was wondering, you brought up this need for a proceduralization function, people to take on the role of proceduralizing scientific evidence for legal and regulatory purposes. It strikes me that this is like a powerful kind of gatekeeping function in some ways, and maybe thinking from the US context where regulation is often very political, I wonder how you could speak to how these proceduralizers get appointed or into a position to do their work in a way that could be consistent both with scientific integrity and also sort of legal technocratic thinking, and also whatever the political situation is at the time.
Thank you very much for your question. First of all, I want to specify that the fact that I was speaking as a researcher, so it's not a recommendation from my institution. Of course, it's just a result of the recommendations that emerged from the work. So you mentioned a gatekeeping function of such a proceduralization intermediary. I would say that in any case, in no case, this function should be mandatory. It should be some function that you can reach if you want to have help on how to translate your work into something that can be used in a legal context. So the idea is really not to have someone who will modify the content of your work, but help you operationalize the legal translation of your scientific work. I don't know if it's clearer now. But it would definitely not necessarily be a function that is proposed or suggested by the CNIL, by the French Data Protection Authority. It should be as administratively independent as possible, and should not be mandatory, and should not invest or engage in the methods that a scientist will use to prove his or her point, to make an evidence. It should just be used as an interface of a translation towards regulation. That was the idea. But again, it's nothing concrete. It's some sort of recommendation out of my observations.
Okay, thank you, Mehdi. Yes, Sebastian, you can ask your next question.
Yeah, thank you. So my second question is for Aileen. So I'm fascinated by your use of measurement and your sort of applications of different theoretical, thickly normative lenses to the interpretation of those measurements. But can empiricism extend to answering these kind of socio-technical structural questions that are embedded in those theoretical lenses? Like, can we have a more ambitious empiricism in this domain? What do you think?
I think I'm going to invoke a phrase I heard recently. There's a new journal, I believe it's called the Journal of Law and Empiricism. And in their announcement, they describe how they're different from other journals. And one difference they cite is that they're open to so-called intriguing correlations. I think these more ambitious questions you're interested in, which to me seem more addressed, say, by Mehdi's case studies than by my sort of narrower empirical lens. I tend to put them into the category of intriguing correlations, which means I think that if you identify, say, the same intriguing correlation from many different angles and with many sort of independent sources of measurement, that can inform your viewpoint. I'm a Bayesian, as we all are, one way or another, even if we don't admit it. So if these intriguing correlations go along with my prior, I update to a posterior that will respond to the world and will research the world to account for, say, a particular view of how the socio-technical system works, what it teaches us, how it structures us. So that's my way of dodging and saying, I think at some point it's beyond measurement, which doesn't mean we shouldn't attempt to measure, doesn't mean we shouldn't generate hypotheses, but does mean we should always have a strong dose of humility and willingness to find evidence that goes the other way. So for example, where we're going to make consequential decisions that turn on our empirical posteriors about the state of the world, we should be very humble in doing so.
Okay, thank you, Aileen. Yes, Mehdi, do you have any follow-up?
No, I was just going to add that it's very interesting that precisely this humility that makes it difficult for scientific evidence to enter legal context, because precisely the risk to integrate a proof about which the researcher himself or herself admits that he is humble and that it's not certain, it's quite contradictory with the idea of integrating it to legal context. That's just what I wanted to add. But we should try.
Indeed. Thank you, Mehdi. We also have a good question from Cynthia. So Cynthia, you can unmute yourself and ask the question, or I can ask it for you. I'm not sure what you are most comfortable with.
I can speak. Can you hear me?
Okay. Yeah.
So I have a question. I'm a practicing attorney, and one of the things that just to kind of formulate this question, one of the cases I was working on, I had to travel to Germany because we needed some documents from a German company, and I had to go to Germany off and on for almost a year because of their protections of their employees. They didn't want one document to come to the United States that would disclose the name of employees and involved with this. They were not involved with the litigation. They were just identified. And while it was a pain because I had to do the travel for almost a year, I was so impressed that they were spending the time and the resources to protect their employees. And I did not know at that time, this is 2001, that this was something that was done. I was not aware of it. And I went to George Mason Law School in the United States, in Virginia, and it has a libertarian bent historically. And they've been in favor of privacy and anti-surveillance as pretty much as a rule. However, whenever I also had worked for the federal government, and a lot of Americans just want things to be free. So they're willing to trade privacy for getting access to, for example, Facebook. But I don't think they were aware that they had choices, that they could demand that, or it felt that we're, as Americans, we're always trading something of ourselves for businesses. And because I'm also copyright background, and I like the moral rights aspect of the Berne Convention. I like all these things about what the Europeans have. So how do we as people in the United States argue against or deal with people who want things for free, but the trade-off is giving up privacy? It still baffles me, because I've been trying to think of ways within the construct of the United States to have assumed rights, the rights of being a human being. You already have these rights, versus having to argue with businesses that you don't get this automatically. This shouldn't be something that is given to you, and then we have to fight for it back. And then I've been having conversations with people like, how do we, with the United States and other countries, come up with some sort of a harmonization of the privacy rules? Because I see that it's not getting any better. I had worked on harmonization for patent laws, coming up with a theory about that, and I was very interested in the TRIPS decisions and the treaties. But I'm trying to think if there is a way to harmonize, because how do we engage with countries and establish ways of thinking that the rights are inherent in being a human versus the rights belong to businesses? So I was just wondering about your thoughts about that, because that I don't see it getting any closer.
Thank you. Thank you, Cynthia. Okay, who wants to start?
I'll start. So Cynthia, I think it's a great question, and one personal anecdote I can share. I'm in my second year of teaching privacy law at Harvard, having just spent some time as an American, but spent a few years in Switzerland. But it is really striking the difference in sort of what is thought to be reasonable or possible, right? Because often you'll hear this American story of, oh, privacy law, it's just not even possible. Like, it would just be a total fiction. Whereas in Europe, you see that there are robust protections, and they are indeed enforced and also respected by firms. So when firms start, say, a new data intensive practice, the question is this a thing? Is this lawful? What would be the lawful basis for doing this? Versus in my brief experiences working in various data intensive startups in the US, is one never asks that question. It's not in the culture legally or vis-a-vis the business environment. You have this sort of separate observation or question of sort of what can we do about what I might frame somewhat judgmentally as the American consumer's addiction to quote unquote free, right? That's sort of, and that goes to this structuralist view of that sort of, that's what we've been encultured to expect. It's something that has happened over our lifetime, since I think none of us are so young that we came of age when consumer capitalism or consumer surveillance was in full throttle. So I certainly remember a time when the things one got for free were few and far between. You know, one paid for one's magazine subscriptions. I think maybe the Yellow Pages, right, was the thing that got delivered for free. And as a kid, I thought that was amazing. You get a book for free, right? So it certainly doesn't have to be that way. We could separately ask, maybe it is a good thing that it is that way, but we haven't even sort of had that policy discussion. I used to think that the US switching over to a more protectionist view like that of Europe was very unlikely, and yet we have some funny hints of it at times, right? When the political stars align. So for example, the TikTok ban that wasn't, arguably, had it been enforced, rather than simply being used to turn TikTok into a platform now that is now incredibly beholden to the specific administration that is suspending enforcement of law against it. But that law basically is saying, no, we won't let Americans, forget about, we won't let them have this for free. We won't let them have it at all, right? So it's not that the US government is incapable, or in some cases, unable or unwilling to have these, in fact, very strong protectionist views of law vis-a-vis commercial surveillance. It is plausible, it is possible, it might happen someday. So lots of responses to that, ranging from the hopeless to the very hopeful. But it's certainly a really interesting time. And even in the new administration continues to be a really interesting time, because very wide swings in this area seem likely.
Thank you.
Thanks.
Yeah, maybe just to add up to this, I agree with everything Aileen said. I would maybe remind ourselves that it's all about power struggle. So what the situation you're describing is users' rights, citizens' rights against companies, right, and individuals' rights, or capitalistic rights, right. The question is to find moments of controversies to have this battle going on. So what you describe is that in the US, apparently the battle is lost. It might be lost, but it's not lost forever. And I would say even in France, the battle might be won a few decades ago, but it's not won forever. And actually, when you look at what NGOs say and so on, even in Europe, like companies really fight to get more and more of our data without compensation, or without even telling us. So what I wanted to mention is the notion of controversy, because what happened in France before we get to have the CNIL and a specific law on data protection is that there was a huge controversy about governments trying to build a huge database of all citizens that could be transferred from ministry to ministry. So all ministries would have data about all citizens. So I will not go into the history of the CNIL and so on, but of course you can read it. But it's this specific controversy that made it possible for the power relationship to be in favor of the defense of users' rights and citizens' rights. And so my recommendation would be, and that's what Aileen was saying, to use any situation to try to build on controversies and make the problem public when you have the opportunity to do so, to work with NGOs, work with parties that are in favor of your cause, so that there is a legitimacy for this right to be defended by politicians and other authorities. So yeah, I just want to remind ourselves on your side that it's not completely lost, and on the side of Europe that actually it's not won forever either.
Thank you, Mehdi. Yeah, the appetite for information, from companies, from governments, it will never go away, right? So it's on us to fight back, and I totally agree with your point of building on these controversies and trying to build something better. Even though, the power balance is not in our favor, Aileen, like you said, in this regulatory space. Okay, we have only 9 minutes, and I still have a bunch of questions that I wanted to ask you, and we still have some good observations from the audience. So let me try to combine everything together. So first, maybe kind of a practical question. Okay, so let's keep it in the kind of a formal lens of enforcement, right? So we're trying to increase compliance with the law, and for us that will be improving enforcement. Just for this question in this context. So the fact that every company today, uses data, processes data, gain insights from data, every company is a data company, right? Means that privacy regulators like the CNIL need to oversight everything, right? There is no company that is not under your supervision as a regulator. And it's of course impossible with any amount of resource to cover that and really question, investigate, and get into the weeds of what companies are doing. So how do you create a culture of compliance despite that huge barrier of resources, right? How do you signal to the market that, you know, human business and they need to comply with privacy law that you cannot really, you know, actively question and enforce in each and every in each and every company, and kind of, you know, complementing that with something that was asked by the audience. How do you move away from this checkbox mentality of compliance and trying to create more impactful compliance with privacy?
Yeah, it's very interesting because right now at the CNIL we are working on automatization of dark pattern detection and see if those tools can be integrated to our daily routine for controls and sanctions. So we've shown in our study on dark patterns that even if it's not enough, systematizing the analysis thanks to statistics, automation, and so on makes it possible to achieve greater robustness of the proof. And in this sense, it's only possible thanks to the association between computer scientists, designers, and as I described. So yeah, one easy answer to just keep close to the topic on science versus regulation would be to keep working and integrating this interdisciplinarity for better systematicity of the proof and better integration of the proof to the regulation.
Thank you. Yes, Aileen.
I'll also jump in. I tend to think cultural changes are perhaps the most important, right? So even with our better resourced enforcement agencies, like, you know, usually in the US, we point to our financial regulators as kind of the gold standard globally for competence and being at least close to adequately resourced and all of that. And yet even there, I think the direct enforcement or even kind of the probability of enforcement is not nearly enough, right? You need to really change the culture. And at least as an outsider to Europe, maybe Europe hasn't necessarily succeeded by some, you know, perfection standard, but certainly compared to the US, the culture is really there, both as to a reasonably high proportion of data subjects being aware that they are data subjects and have rights, right? So there's this culture of empowerment to some extent. For example, my understanding is CNIL gets a few hundred emails and calls per day, sort of asking like ordinary people, not uptight privacy law professors, but really ordinary people. You know, my neighbor has this camera. Are they allowed to do that? What can I do about them pointing a camera at my window and so on? Some people might sort of view that as sort of this culture of tattlers or reporting, but I actually view this as a very healthy culture of being aware of, you know, I am a data subject with rights who doesn't need to just sort of accept these practices. I have, you know, recourse, and I know that there's sort of an established code of morality represented in our law, and I'm going to make use of that. And therefore, for example, in the US, I'm most heartened by and I don't see it too often. I think we need more, but sort of efforts that go more in the way of education rather than say bickering about what new legal reform to propose. At least if, you know, it would be great if we had some, but in the meantime, to just sort of, you know, I often talk to my students who are not in my privacy law course, who are just sort of in my more mainstream torts course. So I get a sample of law students, and many of them are not aware of the extent of commercial surveillance, even though they're really young, right? They're the digital natives, they're still not aware. And B, they're not aware that a lot of it is potentially illegal and that even in the US, they can give some pushback. So if students at an elite law school are not even aware of this, I mean, that is also really a problem. And so my thinking is that much more of it needs to come somehow from the grassroots than from, say, the regulatory agency or from the lawmakers.
Yeah, and I think it prepares us nicely to the next thing I wanted to ask, and now I want us to wear the hat of the researcher, right? And try to kind of describe, detail, and think about the barriers that we as researchers have when we're trying to inform the regulator, trying to maybe improve regulation, right? And we know that in Europe, NGOs are very, very active and successful in nudging big companies, pushing enforcement towards certain places, but not others. So they really have an impact because of Article 80 of the GDPR and how enforcement would look like. Should researchers maybe use them as an intermediary to make an impact? Should they directly create communication with the regulators? How do you see that intersection?
Should I start? Okay. Okay, I want to remind also one thing is that we must not forget that the regulator itself is caught in power struggles. So basically, the regulator needs the legitimacy to act in favor of GDPR and more generally of the rights and so on. And definitely, the working with NGOs to make the problem public will definitely help enhancing this legitimacy, definitely. So my first answer is a big yes to working with NGOs, definitely. Also because they do have the channel to talk to regulators, and they might have the codes to be able to talk to legal authorities. And at the same time, I think we must also nurture the discussion directly with the regulator as researcher to help create this more stable and more lasting channel of conversation between science and regulation. And so I think both go together. NGOs to have like class action and one shot and so on, and the more stable and lasting channel of communication between direct communication with between science and regulation is also necessary. So yeah, I think all fronts need to be tackled at the same time.
Violently agree. I guess the only thing I would add, and maybe as a point of self-criticism, is I think empirical privacy researchers, I could certainly, and I think many in my community could do better to frame our research in a more accessible way. Again, going to my earlier point about educating the general public, right? That sometimes we are so siloed and so incentivized by our publication goals that our institution tells us is our most important contribution. But in a way, if ordinary people don't know or care about our research, maybe we need to push back a little bit on that and think again, sure, it can be highly specialized, but nonetheless, there should be a takeaway message that, can resonate with the ordinary people who ultimately give the regulators their democratic legitimacy, right? So this all has to be in sync.
Thank you, Aileen. So we're just 1 minute before 2:30. I want to be respectful of everyone's time, but I have just a final burning question to two of you, kind of quickly, if that's okay. So how should we operate in areas of scientific uncertainty? I think maybe you were hinting into that in your presentation, but there are areas where, researchers are still trying to figure out what to do. Regulators are facing those, power struggles, resource constraints, and others. But those areas need to be regulated tomorrow morning because they are, in fact, actually determining or setting norms that will be very difficult to diverge from in the future. We can think of, generative AI, we can think of virtual reality, and what do we do there?
So I'll register a little bit of disagreement, maybe. Not that I don't think it's the scientific uncertainty that means we should hesitate per se, so much as we should be careful to remember that strong regulation can cut both ways, e.g. the TikTok ban. And so I would put an enormous thumb on the scale of not rushing to regulate, not regulating without adequate data, regulating with humility.
Thank you. Mehdi, final thoughts?
Yeah, I guess we are in a situation where the president of the United States is very critical of the way Europe wants to regulate everything. But from my point of view, as I said with the case of explainability of deep learning systems, we need standards for the regulation to be operable. But in a context where the tools for explainability here or any standard are not yet mature, I don't think, I mean, at least I think it should be a reason for the regulator to apply precautionary principles and prevent these technologies from being used in context where the harm is impossible to control or evaluate. So that's also why we want to have those studies, is to show the regulator that we do not control enough. And maybe when you don't control enough, you cannot let it go and let it just be as is. So sorry, Mr. Trump, but here I will ask for more regulation again.
That's a wonderful final note. Thank you, everyone, for being with us. Thank you so much, Aileen and Mehdi. That was terrific. I learned and enjoyed a lot. Points in the Q&A, if I missed them, please feel free to follow up with me in email. And if I missed anything, we can further ask our speakers. We will have the recording in our website, so please subscribe and you'll get to know when this is happening, and I'll see you hopefully in the annual event on June 6th and future events. Thank you so much.